Hi, it is 5 p.m. on Thursday, which means that you are at the bar. I bought a bi-monthly discussion about issues at the intersection of law, politics, and culture. Jennifer Braceras' seat today is being filled by Erin Hawley, who is a senior legal fellow at the Independent Women's Law Center. She previously served as an associate professor of law at the University of Missouri, where she taught constitutional litigation, federal income tax, tax policy, and agricultural law. Her scholarship focused primarily on the federal courts, and she's been published in numerous journals on that subject. But it is her expertise on the broader implications and potential limitations on agency power, which is why we brought her on to At the Bar this week. She is a stalwart defender of actual constitutional government. She has some critiques of how it is that we, quote unquote, make law in this country. But the reason I brought her on is because our subject is West Virginia against EPA. And this is a case that is going to be, decided by the Supreme Court this upcoming term. And Erin, can we just start with just laying out what the case is about, what sort of doctrines are involved, and what the broader implications of a decision on this case might be?
Absolutely. So thanks, Inez, so much for having me. And you all should know that Inez is herself an expert on administrative law and certainly a stalwart defender, as you all know, about the constitutional order and the structural constitution. So with respect to West Virginia versus EPA, this is actually a case that has been kicking around the courts, including the Supreme Court, for a number of years now. So in 2015, Congress's proposed cap and trade legislation had failed. It had not passed Congress. President Obama had not been able to enact that into law. So what the Environmental Protection Agency did is they looked around and said, how can we sort of get to this same point? How can we institute basically cap and trade legislation through the administrative apparatus? And that resulted in the Clean Power Plan. Again, this was in 2015. It was an EPA, an administrative rule. And what that rule did was take actually what's been called a very obscure provision of the Clean Air Act and transform it into something that really can regulate the entire nation's energy and how that energy is produced, in addition to who produces it. So the provision at issue is Section 7441D. This is really an ancillary provision of the EPA, of the Clean Air Act, I should say, rather. And the Clean Air Act, just for a little bit of 30,000-foot view, the Clean Air Act basically regulates two types of entities. So the Clean Air Act has jurisdiction over emission sources. And there are two basic types of emission sources. There are mobile and there are stationary. So here we're talking about the stationary category of emission sources. This is all of our energy producing things, such as coal power plants, which are particularly at issue here. And then there's two types of coal power plants. There are coal power plants that were built before the Clean Air Act, and there are coal power plants that were built subsequent to the Clean Air Act. And those two entities are usually governed by different rules. So it's a complicated structure, but generally speaking, grandfathered power plants, so the old power plants that were in existence before the Clean Air Act was passed, are governed by what is known as best available technology. And what this means is that these plants are basically required to upgrade to the best available technology in order to keep their emissions to a minimum, to the least extent possible. But this wasn't good enough for the Obama administration's EPA. Again, they wanted this entire capping trade system. So they used Section 7411D, and they basically set a standard that was too low for existing plants to meet. So this meant that existing plants would be required to reduce hours and or subsidize green energy. It really did implement cap and trade. So in order to keep operating, these existing plants could subsidize things that were identified as green energy. So this idea of being unable to comply with the emissions limits is what gave rise to the big controversy. And we can get into the details of that. But the coal industry was initially represented by Larry Tribe, who's a professor at Harvard Law School. And I loved what he said because it really sort of encapsulates this case. And it says, burning the Constitution, he argued in a brief before the Supreme Court, should not become part of our national energy policy. And what his point was is that we're talking about an administrative agency who is using a little known rule to actually fundamentally change the way energy is produced in this country. That's not how administrative law works. That's not how it should work. So that's a little bit of the background of this case.
Yeah, it's good that you pointed out that Congress actually did consider very similar kinds of schemes, and of course, those schemes could not pass Congress. One of the issues here, if the court gets the merits at all, if they resolve some standing issues that I don't think we'll go into today, which could be a sort of route out for them if they don't want to resolve any of the important merits of this case. But what questions around, or what doctrines is the court going to use to consider? Because the ones that, and I'm contrary to what Erin said, I'm not a real expert in administrative law, but there's an important question doctrine that the courts have been essentially trying to replace actual limitations on the different branches and their powers with, which is essentially saying, well, if the agency is making a sort of, first of all, if Congress speaks clearly, that's one thing. If it's an important question, which seems to me to be a little bit subjective on the part of the justices, if it's a really important question, then we'll assume that Congress has to have made a clear statement, has to have actually spoken to this question. But if it's a question of lesser importance, then we can assume that this was within the broad delegation that was given to the agencies. Do you think the court is going to essentially rewrite, since we do have 5 votes now, potentially, for some kind of limitation on agency power? Do you think the court is going to rewrite those rules, or do you think the court is going to resurrect, as Justice Gorsuch did in his opinion in Gundy, something like a non-delegation doctrine that actually gets to the constitutional problems with the way that we, I don't even want to say make law, but issue regulations that influence millions of Americans in terms of, in this case, energy, but could be any number of legal issues or any number of policy issues affecting anyone in this country.
Absolutely. So I think those doctrines are actually really related. So on the one hand, you've got the you've got the non-delegation doctrine. We've got a child who does not care about the non-delegation doctrine. But with the non-delegation doctrine, you've got Congress, or you've got the Supreme Court rather, saying the Congress basically needs to do its job. It needs to decide those important policy issues. It needs to lay out clear guidelines, as Inez said. But on the other hand, you've got this doctrine that the Supreme Court has been using more and more in recent years, called the major question doctrine. And it sort of gets you to the same place. It says that when you've got something of significant economic or political or social consequence, then we expect Congress to have spoken, and to have spoken clearly on such an issue. And this doctrine really had a resurrection in an interesting and unlikely case. And that was King versus Furwell. And in that case, it was an Obamacare case, as you'll remember. And what the Chief Justice said in that case is that how the insurance industry is structured, whether it's left to the states or the federal government, that is an issue that is too big for the Treasury Department. It wasn't even Health and Human Services, but the Treasury Department to decide. So in that case, the chief invoked the doctrine to say, in this case, Congress needs to speak, or the courts need to interpret. So I think they kind of get you to the same place. My suspicion is that in this case, the major questions doctrine is a lighter lift. I think that there are more members of the court. Justice Kavanaugh has spoken favorably about it. The Chief Justice has spoken favorably about this major questions doctrine. And I think you could get certainly 5 or 6 members of the court to say that when you look at a statute and when the administrative agency takes an ancillary provision that has hardly ever been used up until 2015 to reformulate the energy sector of the entire United States, that's not something that Congress has left the agency. It's something that needs to be decided by Congress itself, as indeed Congress tried to do and failed. So I would be hanging my hat sort of on the major questions doctrine, but I would not be surprised to see a concurrence by Justice Gorsuch agreeing with that limitation, but also saying we've got a bigger problem here, as Inez described it. We've got an agency who is purporting to run the energy industry in our country. And that certainly should be something that the people's elected representatives are discussing and debating and passing laws about, because that way you've got some direct accountability. The problem with these agencies making these rules is they're really hard to change.
Yeah, and there's no direct accountability, of course. They're unelected bureaucrats. They keep their jobs regardless of the consequences of the political decisions that they're ultimately making. Whereas, part of the reason that it's so difficult for Congress to get Congress to legislate is because they are responsive to the American people in some way, and so they're therefore a little bit afraid to go ahead and legislate on some of these questions. It's much easier for them to toss over a broad delegation to an agency, let the agency take the heat because the agency doesn't care about any kind of feedback from voters. And then if the rule turns out to be popular, the politicians take credit for it. And if the rule turns out to be unpopular, they just blame people who don't have to stand for election. So there really is this corrosive form of regulating that it goes way beyond this particular energy sector, right? Or whether coal plants, coal power, which itself is a huge issue, right? Itself is like a major issue, a policy issue in the country. But this really does go to the heart of, can agencies just circumvent? Can Congress basically toss over whatever power it has to the agencies and let the agencies essentially take the heat, even though they don't have to stand in front of the voters? I think Schoolhouse Rock, right, might be an outdated reference these days, but it used to be, the idea used to be that the bill on Capitol Hill, and then it goes over to the agency, and the executive agencies then, implement it or effectualize it, but they aren't making the law. Congress is making the law. To what extent is that even true today? And how much power do agencies actually have? Like what sorts of issues, for example, might be impacted by a ruling that constrains agency power in this EPA case?
That's a great question, Inez. And if you look at the Supreme Court's docket, you will see that a surprising number of those cases are dealing not with statutes enacted by Congress, but by regulations enacted or promulgated by administrative agencies. If you look back a few years, I think it was 2015, Congress enacted about a third as many substantive regulations as did administrative agencies or substantive statutes. So you have 2/3 of the substantive laws that govern things we do every day are coming out of agencies, twice as many out of agencies as out of Congress. And that's super concerning for all of the accountability and delegation problems you mentioned. And these rules really run the gamut. If you are a farmer, you are going to deal again with the EPA and a different statute, the Clean Water Act, and they'll tell you whether or not you can farm, whether there's a wetland that's near or abuts your property, and whether you can till. If you are a business, you will be dealing with OSHA and the vaccine mandates. And that case is another example of a recent case in which the court employed this non-delegation doctrine to say, nationwide vaccine mandates, as the OSHA agency tried to do, that's something that should be at Congress. It shouldn't be left to an agency. So anything from workplace safety, you're talking about an agency, you're talking about farming, you're talking about everything from how employment runs, really anything you can think of. There's a Supreme Court opinion that says that agencies now touch every nook and cranny of daily life. So if you're thinking about a regulation that impacts your life, chances are that regulation has been passed by an administrative agency rather than enacted by Congress. Congress.
The last time that the courts really cited or had any kind of non-delegation doctrine, which is to say that the courts actually enforce the limitations of what Congress can and can't give away to unelected agencies in terms of power. We're back in the New Deal, right? The early New Deal cases. So you have J.W. Hampton against the United States, and then you have the famous case Schechter Poultry against the United States. These are both cases that are essentially pre the change in the Supreme Court, where FDR threatened to pack the court. Now, there's some like academic debate about whether or not that made a difference, or whether it was just, sort of appointments and turnover. But regardless of why it happened, there was a very sharp shift in the court's view of what powers Congress could and couldn't delegate. And courts kind of packed that doctrine away and essentially have ignored its existence for the last century. I mean, what really would sort of an originalist court actually enforcing a non-delegation doctrine, what would that do? You mentioned that these regulations touch every area of life, but how would it change sort of the dynamics in Washington between Congress and the president and the court? I mean, how would it sort of redraw the lines to actually start to enforce serious limitations on what Congress can delegate?
Well, I think that the West Virginia versus EPA is a prime example of that. So under sort of any reasonable, I think, view of either the major questions doctrine or the non-delegation doctrine, questions like this, how the energy sector is comprised and who is composed of it or in that energy sector, those questions are something that should be decided by our elected representatives. And that's, of course, what Article 1 is all about. Article 1 of the Constitution gives to Congress the ability to make law. Certainly, our federal government has gotten bigger and bigger. So there's an argument that they need some help. But that help can't come in the form it is currently in. And that's, again, the cap and trade legislation failed. And then an agency tries to do that very same thing. So that seems to subvert the constitutional structure. So I would think you would see in cases like West Virginia versus EPA, the court saying, no, this is a question that is too big for an agency. It's a question that Congress did not clearly delegate. Again, the provision they're citing to the EPA is this provision that's barely been used. So for both of those reasons, they would send it back to the agency. The agency would not be allowed to so radically transform the energy sector. And if Congress chose to regulate greenhouse gases in some form, then it would be up to Congress to enact that legislation, not an agency. So I think you would see a lot more of the major actions coming from Congress, which I think is where they're supposed to be.
Yeah, I guess the answer that I've been hearing from a lot of leftists, other than the sky is going to fall because the world is going to end in 7 years if the EPA does not do this. I mean, setting that kind of policy objection to the side, I've heard a lot of sort of legal commentators express the fear that this direction of the court could overturn modern governance. That in fact Congress cannot legislate on even these big questions. They've proven that they really can't. The left relies a lot on arguments from expertise. They're saying these topics are scientific. They require a certain amount of expertise. These decisions need to be made by experts. I'm trying to give the best argument I can. What the impact on climate change, from coal plants, that's a scientific and a technical question. And therefore, these agencies in a modern government have to be able to keep up with these different industries in a way that Congress just lacks both the expertise and the ability to issue law in a timely way that would actually keep up with these industries, and that without having this modern governance structure of the agencies being able to make rules on subjects like this, even rules that have even the most tenacious connections to actual statutes that Congress passed, that functionally Congress isn't going to be able to keep up, and we're going to turn into a country that is largely controlled and dominated by industries that that are just way, several steps ahead of Congress, who really don't, the members don't really understand the questions on which they are legislating, and anyway, they'll take too long. So how would you answer that kind of objection that our entire edifice of modern governance really does depend on experts in agencies being able to keep up, regulatorily speaking, with industries?
I think, first of all, that might say something about the size of our government, which is obviously much larger than the framers ever intended. We've got the Commerce Clause power that extends far beyond what the framers intended. So you got the question, just, is this the ideal size for government? But assuming that we want a government who does all the things the government currently does, I still think you need the constitutional separation of powers. And the reason for that being is that it is liberty enhancing. The way the framers set up the Constitution, you have to have all three branches work in concert before they can curtail your liberty. Under the current administrative state, you can have a regulation issued by an agency. You can be called before that agency to account for your actions, and that agency can issue punishment. So that the agency is entertaining all three powers of the different branches of government within one building, sometimes within one single agency. And that's inconsistent and ultimately inconsistent with the liberty function of the separation of powers. And as far as the practicality goes, it's true that we're requiring Congress to do more. There might be some growing pains, but this doesn't mean that Congress can't direct the agencies. As the non-delegation doctrine is stated, it means that Congress must, in fact, delegate to the agency. So that means they have to give them some clear guidance on what needs to be done. The administrative agencies can still provide expertise. They can still provide all sorts of background knowledge. However, it's Congress that should be making the policy shots.
Where's the line then? Because this is actually one of the, I think, the more legitimate objections. I perhaps am not being entirely fair to the world as falling objections, because like you, I think a lot of the way our current government operates is very contrary to the constitutional design. And that's it would be a very good thing if a lot of quote unquote modern governance came to an end. But one thing that is a real objection, I think, here is the line between interpreting and issuing regulations based on statutes that Congress passes, and essentially pulling new powers out of very tenacious connections. Policing that line is not a like clear and bright thing. And so one of the objections I've heard is that this is going to hand enormous power to the courts, because unless you have this very deferential stance towards agencies and towards their expertise in terms of interpreting the statutes that Congress has enabled them to interpret and then regulate on the basis of, that somehow courts are going to be able to read a lot more of their own policy preferences into, let's say that it's an important question doctrine, a revamped important question doctrine, right? That they're going to be able to pour a lot of their own policy preferences into this ultimately subjective line about how far is too far in terms of, what's a question that Congress did speak to, and what's a question that Congress did not speak to.
Yeah, so I think there's a couple of things that can respond to that. First, I always have to go back to the Constitution. I think this is how it was set up. But in addition to that, I think that you would have a Congress that gets more engaged and more active if the court requires them to. And currently, as you know, if a statute is overturned by the court, it's pretty hard to get Congress to reenact it or to get Congress to respond to a Supreme Court decision. Given the legislative process, that just doesn't happen frequently. Maybe that would happen more frequently, which would be a good thing to have Congress reacting to the Supreme Court. But in terms of the interpretation, I agree with you that we want to be careful with giving courts too much sort of latitude. I think judicial restraint is a good thing, but Article 3 does give the judiciary the power to interpret the law. And that, of course, includes statutes and regulations. So it seems that the Constitution vests that interpretive authority with the federal courts. And the federal courts, I think, are bound, or at least judges who believe in originalism and textualism are bound by the words that the statute say. So if a statute says X, then a judge should not be able to say Y. So keeping judges faithful to the text is always important, but would become especially so in a realm where you have less deference to administrative agencies.
What about the objection then that we are headed into another age where the courts become very active in terms of striking down a lot of, let's call it, I don't even want to call it laws that Congress made, because as we see, it's often not laws that Congress has made, but where courts become very, very active in stopping or reversing a lot of what the federal government wants to do. This is a great question for you, because you did actually clerk for the now Chief Justice Roberts. It seems that he's very, very concerned about the reputation of the court and maintaining the reputation of the court as apolitical. If the courts are constantly policing the federal agencies, that means they're going to be wading into a lot of political conflicts. Do you think there's a risk that there's going to be a sort of corresponding drop in the trust in the courts if they're sort of they're getting their hands a lot dirtier in terms of the political process?
That's a really good question. And I think that, again, the doctrines that constrain courts, originalism and textualism, and even the doctrines that talk about, don't decide a larger case than is before you, all of those things are designed to constrain the discretion of courts. When you're talking about the courts getting more engaged vis-a-vis agencies, I think it's a little different than when you're talking about the court vis-a-vis Congress. When the court is talking about a congressional statute, they do have this idea that they are dealing with a coordinate branch of government that is equally entitled to interpret the Constitution, to pass statutes. And so they're dealing with another constitutional actor. Administrative agencies are a little different. In order to fit within the constitutional structure, they're best funneled within either the executive or the Congress. And it seems like they need to fit within either. And if they're congressional agencies that are aiding in writing and promulgating congressional policies, then that really does get to the non-delegation doctrine that you were talking about. And we need to have Congress superintending those agencies. Hopefully that would sort of obviate conflict in the beginning, because you would have Congress and the elected representatives really riding herd on these agencies. And then, but if it is just a court versus agency, I think maybe there might be less deference there than court versus Congress.
Let's get into the deference question. How does this interact, this entire, either whether we call it non-delegation or we talk about it as important questions, how is this going to interact with what seems to be an appetite on the court to really whittle down on agency deference, period, in terms of interpreting the statutes? Because I was actually, frankly, surprised not to see more of that in this case, and maybe that was my surface level understanding of the case. But I was surprised that there was less talk about whether the agency's interpretation of the section you cited, and I don't remember the number of it, but the section you cited where they're pulling this sort of tendacious relationship to regulating greenhouse gases out of. What about the deference? Are they entitled to interpret that statute? It seems like the courts have in the past given such enormous deference to agencies in interpreting the statute that cases like this one are inevitable, in the sense that if you give a government agency very, very broad deference, they're of course going to interpret the statutes that enable them in the broadest possible way to increase their own power. But how does this interact with, say, the narrowing of either Chevron deference or, deference to agencies in general?
Absolutely. So the major questions doctrine and the non-delegation doctrine come into play before the deference question. So that's one reason I think you don't see as much about Chevron and the our deference doctrine. Or it would just be Chevron because it's a statute in this case. And the idea is that even before you get to the deference question, there are just some questions that are too politically, too socially, too economically important for Congress to have left to the agency. We see that again in the example of the Obamacare case. We see that in the example of the vaccine mandate. We see that I assume that 4, 5, 6 justices will find that in West Virginia versus EPA, that the restructuring of the energy sector is something that is too big for Congress to leave to the agency to interpret. If, on the other hand, the court finds the major questions doctrine does not apply, then they'll get into Chevron and they'll ask whether it's a reasonable interpretation of the statute. And as you said, there's a pretty good argument to make that this ancillary statute doesn't apply to this situation. And you get sort of the same ideas, the same arguments in favor and against Chevron as you do the major question doctrine and non-delegation that you were explaining about efficiency and expertise and all those sorts of ideas, judicial interpretations and judicial humility, all those things come up in Chevron and our deference as well.
So do you think it's possible that the next few terms, the court is going to chip away at both of these kind of simultaneously, that either we're going to get a important questions doctrine that has so much more teeth that courts are less frequently getting to the question of agency deference, and then simultaneously when they do get to the question of agency deference, that we're going to get some decisions in the next few terms that will narrow the deference that courts are going to be giving agencies. I mean, this is very exciting. I mean, to conservatives who care about this kind of balance of power, it seems like there is a real possibility now that the courts will constrain, like meaningfully constrain agency behavior. And it seems to me that it's, we've had the thumb on the scale essentially for all of the transformational reforms that the left wants to make for basically a century in terms of having agencies that are able to circumvent voter opinions on important questions of policy.
I think that's exactly correct. And I do expect that you'll see movement in those areas probably simultaneously and working together with the major questions doctrine, with non-delegation doctrine, with the Chevron doctrine. And even a couple of terms ago, the Our deference case came up before the court. And I think some of us were surprised that the Supreme Court did not, in fact, overrule Our deference. And what Our deference is a step beyond Chevron. So it allows administrative agencies to interpret their own regulations, and then the court has to defer even to that interpretation. So that the agency writes the rule, it writes the interpretation, and courts have to defer to all of that, which, as I think it was Justice Scalia pointed out, like you're deferring to that doesn't make any sense because you're giving a lot of running room to administrative agencies who are not empowered to make the law by Congress. Well, in the case, the administrative agencies side sort of won. But in a way that Justice Gorsuch described as sort of a zombified version of Our. So Our sort of came out of the case, but limps along subject to 6 or 7 exceptions. And so you may see some cases like that. So maybe Chevron survives, but only in a very weakened form. It only applies to sort of lower level decisions. Otherwise, the major question doctrine kicks in. And so I think this is an exciting time for people who really are attentive to and care about the separation of powers. There are structural issues that impact, as Justice Scalia and Chief Justice Roberts have both said, the way we are governed. And I think that's such an important point. It's not just this archaic way that the founders set about setting up the government, but rather it does impact our voices and whether the people we vote for are able to implement policy. Are we able to vote them out? Or is it instead an unaccountable agency that's making some of the most important decisions for our lives?
I think to wrap up here, I want to ask you maybe a more philosophical question, which is, can you take politics out of policy? It seems like the underlying principles of the way our government has operated for the last century or more, really since the progressive era, has been that there is such a thing as apolitical administration that is equivalent to good governance, right? That a lot of these questions, especially in the modern world, like some of the critiques we touched upon, a lot of these questions in the modern world they're too technical, they're too scientific, they're too sort of detail oriented to expect a generalist like a Supreme Court justice or a generalist like a U.S. senator, right? To be able to make decisions that are competent in those subjects. Correspondingly, and like I guess on a different track, I think for the last, especially since Donald Trump was elected and he took his 4 years in office, we've really seen a corresponding plummeting in the trust in that these agencies are apolitical, right? That, for example, the DOJ or our intelligence services are apolitical, or that they're doing their jobs without regard to sort of the politics of the matter. And we have a lot of people in this country who really doubt that at this point. They really doubt whether, the FBI, your FBI agent is able to separate, for example, his actual personal politics from the way that he does his job. So I guess the philosophical question I want to ask you is, do you think that there is sort of a technocratic or apolitical way to govern a large country, a large and complex country, like the United States of 330 million people? Or is politics an inherent part of governance? And how do we balance out the need in the modern world, as the progressives argue, to be able to really rely on a certain amount of expertise with the need to actually make sure that we're still a government of the people, by the people, right? For the people. How do we balance those two things?
That's a really great question. And I think those ideas toward efficiency and expertise and technical understanding were sort of the foundation of the administrative state way back in the 1930s. But as for me, I think my vote would have to be on the side of liberty. And again, if you think about who it is we want to be governed by, is it by ourselves? Are we a people who are able to vote for representatives, for congressmen and senators who represent our interests? Or are we going to leave it up to people who may have expertise, whether or not we agree with them, whether or not they have our best interests at heart? And so I think there is a fundamental sort of divergence about how we see government. And if you think back to Madison, Madison was concerned. He said, if we had a government full of angels, I'm misquoting him here, but if we had a government, men were angels, and the government was made up of such as of these, then there would be no need for this check and balances. There would be no need for the separation of powers, because we'd have fantastic government. But the truth is that men and women are fallible. They have biases and interests. And so I really trust the American people to be able to work through their elected representatives more than I would trust sort of an elite bureaucracy, however technical, whatever sort of technical expertise they might have.
Yeah, it's really interesting to be having this conversation, right, as we seem to finally be at the close of a pandemic that was largely governed by bureaucratic and technical expertise without regard to the sort of political questions involved, right? A political question would be, a scientific question about coronavirus might be, how does this virus spread? What mitigation measures might actually, reduce the spread? And of course, that's all, is completely fallible as well, as we've seen. It's difficult with a novel virus to even make scientific pronouncements. But the thing that, Anthony Fauci can't really do, or ought not to, but unfortunately, we really did govern ourselves this way during the pandemic. Somebody like Fauci shouldn't be making the decision of, what mitigation measures versus what counter, what are the downsides and upsides of implementing particular measures.
We should shut down schools forever.
Right. Those are inherently political questions, right? How do you trade off not having kids in school for a year and a half in many states versus, how much spread can be controlled through lockdowns? Like, that's not a scientific question. It doesn't matter what your scientific priors are on that. That's not a scientific question. It's a political question. And it really seems like it's an interesting time to be having all of these discussions about what the role of expertise and technocracy and unelected bureaucrats really is in our governance, and where, the voice of the people should really be represented through our elected officials rather than the unelected. But Erin Hawley, go ahead.
And the good part of politics too, I think you see moms, they got sort of criticized for it. We see moms standing up for kids, and you see active engagement in communities and school boards and the like, as people were fighting through the political process for what they thought was best for their children. So you see that politics at work, as you say.
Yeah, absolutely. This is in fact how a republic is supposed to work, and it seems like we've forgotten that. But maybe through a combination of these Supreme Court decisions that are coming up in the next few terms, we might actually get a lesson and start working that atrophied muscle of self government, which really has been slack for far too long in this country. I know you agree with that underlying sentiment. But Erin Hawley, thank you so much for joining At the Bar today. At the Bar is a production of the Independent Women's Forum. It's available for viewing on Facebook, YouTube, and IWF.org. You can also listen to it in podcast form on iTunes, Spotify, iHeartRadio, and anywhere you get your podcasts. We hope you'll rejoin us in 2 weeks for our next virtual happy hour conversation about the issues at the intersection of law, politics, and culture. And then until then, cheers.
Cheers.